mistakes people make in an uncontested divorce. Uncontested divorces are those when both parties agree completely on everything. Now, a divorce has 5 different parts. There's the status of the marriage itself, whether you're divorced or you're going to continue to be married but live separately. The division of assets and debts, spousal maintenance, parenting plan, and child support. Of course, those last 2 are only relevant if you have children who still live with you. Now, not everyone needs an attorney. I think that's very clear. Don't know if every attorney would tell you that, but we're willing to tell you that. However, it's usually only people who don't need an attorney if they completely trust the other spouse. There's no assets to fight over. They know completely the financial situation of both of them, of both parties, and otherwise work well with their spouse and don't need any help reaching agreements at all. Usually these people who don't need an attorney don't really have much to fight over, or they can co-parent completely without any help. As you might imagine, not everyone falls into those categories, but if you do, maybe these tips will help you avoid some of the mistakes that we see. A lot of what we do is people come to us and they want to change divorce papers that they did by themselves, that they worked with the other party and there was no fighting about it, and they entered these in. The top mistake that we see is in the parenting plan. A big mistake that people make is that they believe the parenting plan is, or they have some agreement that they're going to change the parenting plan, or that they're going to do something different than what's written down in the future after certain things have been done. Let's say one spouse gets a job and has an apartment where they can have the kids at. Or maybe one spouse, one spouse is going to move, and after everyone's settled, then we're going to do a different parenting plan than what's written down. Problem is, if it's not written down in the parenting plan itself, it can be very difficult to change. The courts, in fact, and the legislature have said that a parenting plan should only be changed under certain conditions. And if those conditions aren't met, you can't change it. And so there can be a great deal of work on the other end if the parenting plan itself doesn't say after a certain amount of time or after this we agree to change the parenting plan. So that's something that needs to be in there if you contemplate a change, or if you contemplate, or if you think that if you ever want to change a final parenting plan. In fact, the best way to work that out is to get the parenting plan that you really want right from the get-go, and that's what should be written down, and that's what you follow. And you only change it if there's some kind of big change in your lives. Then you go and change, and it's in the best interest of the children. At that point, that's when you go and change the parenting plan. Okay, second one, it comes to the issue of spousal maintenance. This is also known as alimony in some places. In Washington State, we say spousal maintenance because the idea behind it is it's a transfer of funds, usually on a monthly basis, but it's based on income to support the other spouse until he or she can receive training or otherwise create a basis for their own work and income that would roughly match the lifestyle that they enjoyed during the marriage. So, rule of thumb, it's based on need and ability to pay. What we see is that a spouse comes to us and says, well, I just agreed to these papers because I didn't want to fight. And so it's either at zero or or on the other extreme, it's an amount that's high enough that they're not able to, even though they were the say the main income generator during the marriage, that spouse is no longer able to maintain their own lifestyle. They're stuck living with mom and dad, or their spouse has now moved in with a boyfriend or girlfriend, and they're not married, so it doesn't automatically terminate, but they still have to pay it because they agreed to pay it for X number of years, or maybe there's no end date on the spousal maintenance. Washington state law generally has a much shorter time frame for how long spousal maintenance is to last, and it depends on the relationship. It depends on the income difference between the two spouses, but it almost never would last as long as the marriage lasts, and it's usually 20% of the length of the marriage or thereabouts. Now it can be different amounts and different lengths, and there's different reasons to do that, but those two extremes are things that you need to worry about, because there is a provision in the law that allows you to do that, and wanting to avoid a fight is I mean, if the other spouse has significant income, then you shouldn't just avoid the situation to avoid the fight if you need the support, or vice versa. If the other spouse doesn't need the support and it's not automatic husband to wife, then that's something that doing it yourself probably isn't going to work. Just agreeing to agree isn't healthy for you, and doesn't help you rebuild and recover after the divorce. Let's see. Next thing that we see is when spouses have been married for a length of time, and in certain careers, there's often a pension or retirement. Pensions and retirements are usually funded with pre-tax or untaxed contributions, and then they're taxed on after you retire. They're taxed as regular income after you hit retirement age. So we see people who try and do it themselves, they've either completely skipped over the question of retirement, or they have some kind of provision, but they haven't taken all the steps necessary to secure their rights. And at a certain point, if you don't do it, you've given up what the agreement was and what the divorce papers say. I mean, once the retirement, and there's different treatments depending on if the retirement's in pay or if it's paying out or not, if the spouse who accumulated the pension or retirement has already retired. So there's a lot of different factors there that you have to worry about, so that you can make sure that you get you address that correctly. But a retirement or a pension is community property for all contributions or all the value that accumulated during the marriage. And so that is something that should be accounted for in the division of assets when you're dividing it. One spouse, just because it's their retirement account, doesn't mean they get to keep it. On the other hand, because it's taxed very in a particular way, to avoid a tax penalty for something that would be considered an early distribution of the amounts in the retirement account, you have to do what's called a qualified domestic relations order in some cases, or some kind of order from the court in other cases, that allows plan administrators to divide retirement accounts so that there's no tax penalty involved. And if you don't follow those steps to doing it, you either don't get any benefit at all from the retirement account, or the benefit that you do get gets eaten up by the penalties and taxes that you shouldn't accrue if you do it in the correct manner. So that's something else. A DIY, do-it-yourself, uncontested divorce. That's something that that's another mistake people make when it comes to retirement accounts. So that's again a complicated issue. Next, and number 4 is the treatment of debts. Big mistake we see in this area is when a couple has fairly significant debts and one spouse is going to take them all, and part of the plan is bankruptcy or something else, or it ends in bankruptcy. Problem with one spouse taking all the debts is, one, if that spouse doesn't pay the debts, it doesn't matter what the court documents say, those creditors can still come after you. And so if there's no way that spouse can pay all the debts, you still might be on the hook. You still might get calls from collection agencies or something else and be forced to bankrupt yourself in order to escape those debts. So just giving them to one spouse isn't good. Now, the other thing, if that spouse takes those debts and files bankruptcy, well, that takes care of it for them, but doesn't necessarily take care of it for you as a couple, because those creditors aren't bound by the divorce papers again, right? That spouse is off the hook. The creditors can no longer collect from that spouse, so they're going to go after the other spouse who didn't bankrupt, and that spouse may be forced to go through bankruptcy as well. So dealing with debts, you have to have a plan for how you're going to deal with it and be on the same page, so you know what the consequences are, you know what the expectations are. Now, it is possible for a spouse who paid their share of the debts and one didn't pay their share. You can, in many cases, there's a hold harmless clause, meaning if creditors come after you for a debt that the other spouse was ordered to pay, you can go through the divorce courts and go after them. You can go through the divorce courts to go after them, but again, that's something that you could have avoided had you gone about it, talked about it, and figured it out before the debts were divided and before you entered the final divorce decree. Now, the last one is one that's surprisingly common when people do divorces themselves, either through online or some of these services, is that they don't go through the entire process. They file the documents, but that's it. They don't follow through after that. And so at the end of the day, their case gets dismissed by the clerk because there's no action on the case and no final documents, and or they don't finalize it in a way that the court can recognize, and they're still married. It's surprising how many people come to us and they find out that they're still married to their former spouse, and we have to either dig up the old case or file a whole new one and start fresh from the beginning. So those are the those are the 5 mistakes that we see. If you have any more questions, feel free to please contact us. We'll see if we can help you out. Thank you.